morning, everyone. We started 2 minutes behind time so that we give everyone time to log in. And I see people are still doing that. So that tells us how significant this topic is today. We have more than 2,500 people registered for today's webinar. My name is Shana French, and I'm here today with my colleague, Arash Farzam-Kia. The topic today is the future of remote work, practical considerations for employers. The format for the morning is as follows. We'll present from 9 a.m.-ish to roughly 10 a.m. and then answer questions until about 10:30. If you have a question for us, please type it into the Q&A box on your screen, not in the chat box. That should be disabled. We're going to do our best to answer as many questions as we can, but if we don't get to your question, please reach out to us after the presentation. Finally, a recording of this presentation and slide deck will be on our website in about a day or two. One of the lasting impacts of the COVID-19 pandemic on the Canadian workplace will likely be the change in how and where employees work. Many organizations have embraced hybrid and fully remote work arrangements as the new normal. Organizations are also increasingly comfortable with having remote workers living in jurisdictions other than that of the home office. And while that flexibility can be an attractive option for both employers and employees, having remote workers can change the legal obligations on an employer. So today we're going to have 4 different topic areas that we're covering. First, Arash is going to talk about when a remote worker relocates out of province, what issues arise, and how you can mitigate the risk associated with these moves. As you will see, much of the discussion centers around the question of what's the governing law? I will then take you through performance management in the remote work context, legal consideration with the tools we have to monitor remote workers, and what we do with the information we collect, including when we can discipline or terminate. We'll move to our third topic, health and safety, looking at when the legislation applies to remote workers, with a closer look at online bullying, harassment in the virtual workplace. Finally, Arash will pick it back up with our last topic, employment standards and human rights, as we discuss special considerations in a remote work environment. So, Arash, over to you.
Thank you, Shana. Good morning, everybody. The first topic that we'll cover today is interprovincial or international relocation. We will look at the legal obligations that an employer will want to explore when they have an employee who has moved out of the province or out of the country. With the exception of federally regulated employers, and the issue of cross-Canada mobility is significantly simplified for such employers. Generally, the minimum employment standards that will apply are set by the province in which the work is being performed. For remote workers, this will mean their province of residence. Similarly, an employee who moves from one country to another will likely be subject to different employment laws, and the original legal framework under which they were hired might no longer apply. For the past number of years, we have seen a trend of more employees working from home. This is facilitated not only by a tight labor market, where more and more employers have been competing for a smaller pool of qualified employees, but also by the availability of technological solutions which facilitate remote work. Nothing in the legal landscape will really change when a remote worker relocates from within their home province. They're subject to the same employment laws. For example, an employee who moves from Toronto to Ottawa will be subject to the same labor and employment laws because they moved within the same jurisdiction, namely Ontario. But if an employee relocates from one jurisdiction to another, for example, from Ontario to BC or Ontario to New York, then that will likely give rise to additional risks and obligations. There are 2 ways in which an interjurisdictional relocation may impact an employment relationship. First is the likelihood that an employee who permanently moves from one jurisdiction to another will be subject to the local labor and employment legislation. And when we say local, we mean local to where they are living and where they are performing work. As you all know, in Ontario, the Employment Standards Act 2000, which we call affectionately ESA, governs employment standards such as hours of work, rules for overtime, and entitlements upon termination. ESA applies to work that is done in Ontario. It also applies to work that is done in both Ontario and outside Ontario, provided that the work that's performed outside Ontario is a continuation of the work that's done in Ontario. This is more of a temporary carryover, like when somebody in Ontario is on a brief assignment to another province. An employee who moves from Ontario to another jurisdiction on a permanent basis will likely no longer be covered by the Ontario ESA. They will likely be covered by the local employment standards legislation. This can catch employers by surprise, given that their operations have remained in Ontario. But the legislation will look at where the work is being performed. And if it is remote work, the province of residence will likely take precedence. This is a good time to remind everyone that an employee cannot contract out of the minimum employment standards legislation. A lot of times, when managing this situation, an employer makes the mistake of assuming that because the employee started in Ontario, or that they continue to work under an office in Ontario, that Ontario law will apply. This will be a mistake. If we continue to treat an employee as governed by Ontario law, because we did not know that they had relocated, or because we didn't understand the implications of such relocation, or because we wanted to standardize our HR operations, this will only be a real issue if the employee has a greater right or benefit under the other province's legislation. And that's because we can never give an employee less than they are entitled to under the applicable employment standards. If an employer was lucky, the employee checked first before moving to another province or another country, whether for several months or permanently. With respect to an international relocation, a request in advance provides employers with the opportunity to explore whether having an employee perform work in another country triggers immigration, tax, or employment law issues. In most cases, the answer will be yes. While the pandemic brought incredible fluidity to the workforce, in most countries, the laws have not yet caught up to the concept of international remote worker. The key with an international relocation is to work with local counsel in that jurisdiction to understand the impact on the employer and to understand whether the risks can be managed or whether the relocation is even feasible. The second way an interjurisdictional move can impact an employment relationship is by impacting the enforceability of an existing employment agreement. For example, in Ontario, some employment agreements contain provisions limiting the employee's rights upon termination to the minimums in the ESA. Courts in Ontario will enforce such provisions, so long as they are consistent with the ESA. If an employee moves from Ontario to another jurisdiction, such contractual terms might be contrary to local laws and may be unenforceable. An employee moving out of Canada and performing work from another country is a special case, however. A hard lesson for many employers during the pandemic was how to manage the legal implications of an employee relocating to another country. The decision of the Ontario Labour Relations Board in IBM Canada Limited is a great illustration of the issues with an employee moving to another province. In this case, the employee was hired and worked in Ontario, including a period of time as a remote worker. The employee then relocated to British Columbia with the employer's agreement. After almost 2 years, the employer required the employee to return to Ontario. The employee refused. The employer took the position that the employee had resigned. The employee claimed that he was dismissed and sought severance pay under the ESA, under Ontario's ESA. And the reason for that is that Ontario's ESA is more generous than British Columbia's in terms of rights upon termination. The board held that the ESA did not apply. The board held ESA applies to an employee if the work is being performed in Ontario, or the work is being performed both inside and outside Ontario, but the work that's performed outside Ontario is a continuation of the work that's performed inside Ontario. The board held the ESA applied to the employee when the employee worked in Ontario, but that it did not apply once the employee relocated to BC. We suggest a number of strategies for mitigating the risks associated with remote work and relocation. First, if you intend to permit an employee to work remotely, ensure that the agreement with the employee is explicitly conditional on the employee working within the home jurisdiction. Second, if you find out an employee has relocated to a different jurisdiction without your knowledge, require them to return. Obviously, some period of transition might be necessary, but you will want to explore that with legal counsel. Finally, if you agree to an employee relocating internationally, ensure that your policies and the agreement with the employee takes that into consideration, from the choice of law to the applicable policies and benefits. One final point, the nature and degree of risk posed by interjurisdictional move depends on the individual circumstances. To properly assess risk, it is critical to have a clear understanding of the local laws. What we very often do and recommend is that we vet the agreement with local counsel to avoid any legal landmines. Often, though, the starting question is whether the relocation is even permissible from an immigration perspective. And secondly, whether the relocation will trigger corporate tax liability in that jurisdiction for the employer or for his parent company, as the case may be. With that, I'll turn the floor over back to Shayna to talk to us about the next topic, which is performance management.
Thank you, Arash. A challenge at the best of times, but increasingly complex in the remote or hybrid work environment. One of the guiding principles for managers to effectively develop their team and help their employees succeed is engagement. And traditionally, we know employees who are connected to their work, their workplace, and their teams will outperform disengaged or disenfranchised peers. So recognizing engagement and performance are two critical metrics in developing employees and enhancing productivities. Many employers are striving to find ways to measure these elements in the absence of physical presence. It's harder to do check-ins in the remote environment. And I know many employers find that a regularly scheduled one-on-one is a valuable tool, and it's definitely one that should be utilized. Many are finding it doesn't fully replace the early warning system that physical and organic check-ins provide. So this means that some employers are looking to electronic monitoring tools to supplement the gaps of remote work environments. And that can sometimes include time tracking software. Although electronic monitoring, whether time tracking software, keystrokes, computer cameras, or chat logs, can provide effective tools to manage productivity and time allocation, employers need to be mindful of the legal issues and how we navigate the risks. We look at electronic monitoring in terms of legislation, and it's often referred to as surveillance because it is a form of employee surveillance. So we look at the legislation and we look at the case law to see what it tells us about privacy, monitoring, and what we do with the information we acquire. We've always looked at the collection, use, and disclosure of performance tracking software tools through the privacy lens. And recently in Ontario, we added an additional layer with the changes to the ESA in the fall regarding electronic monitoring. Ontario is the only Canadian province that requires an employer to have a written electronic monitoring policy as of October 2022. So an employer with 25 or more employees must have a written electronic monitoring policy. Of course, the ESA doesn't define electronic monitoring. I'm not clear if that's a good thing or a bad thing. We'll see when the cases start to shake out. But we know it likely includes GPS on a company vehicle or cell phone, camera, computer program, or app to track where and what an employee is viewing or writing. So what does the policy have to have? Well, it has to tell employees if they're being monitored electronically. And if they are, there are certain requirements. The policy must state how and in what circumstances the employer monitors employees, and it must include the date it was prepared, the policy was prepared or amended. And once the policy is prepared, the employer has to provide a copy to each employee within 30 days of the policy being amended or prepared. And for new hires, they have to have it within 30 days of hire. An employer has to retain a copy of the policy and any revised versions for at least 3 years after the policy ceases to be in effect. So that's important in terms of ensuring that versions that have been circulated and administered to the employees have to be retained for record-keeping purposes. Finally, we want to make sure that the policy identifies the purpose for which information obtained by electronic monitoring may be used by the employer. So that's for employers with operations in Ontario who are governed by the Employment Standards Act. For employers who have operations in other Canadian jurisdictions as well, you're going to want to ensure that your local operations are compliant with any legislation in those jurisdictions. For instance, British Columbia, Alberta, and Quebec all have privacy legislation that requires an employer to ensure any monitoring complies with very specific requirements around the collection, use, and disclosure of personal information. It needs to be limited to what's reasonably necessary, and there are parameters there that employers really do need to be mindful of. So that's the legislation. What are we seeing with the case law? As a general premise, in a non-unionized setting, an employer has more discretion to engage in surveillance, subject to the legislation I just discussed. But in a unionized setting, arbitrators have recognized privacy interest, and an employer must demonstrate that there's a reasonable basis for surveillance, the surveillance has been reasonably conducted, and there was no less intrusive method to obtain the information. And this case of IUOE Local 793 and LIUNA Local 183 is an excellent illustration of the principles applied by arbitrators. So in this case, the unions challenged the use of a phone app through which employees clock in and clock out with a selfie. They literally take selfies of themselves while they're clocking in and clocking out to avoid any buddy punching that we see with the time lock monitoring. Or sorry, with the time clock. There was concern with the use that employees were using their personal devices and that employers could use the app to track the employee locations, including when off-site. The data was also stored with the third-party administrator off-site. And to use it, the workers had to accept the privacy policy. There was no other way to track the time. So they had to use the policy to track their time and to use, or had to use the app to track time. And to use it, they had to accept this very robust policy, which included an agreement to their information being sent to marketers as determined by the third-party app administrator. The employer relied heavily on management rights and argued that it was much more efficient and accurate time tracking, and that the new app wasn't materially different from previous applications that had been used to serve those functions. But the arbitrator ruled the app was an unjustified intrusion on employee privacy. The location tracking could be engaged outside of the workplace. It wasn't intuitive how to disengage it. A lot of times it was kept running on a background screen, sending information every 5 minutes, and that the data collected would be provided to a third-party app administrator, which then had the right to hold, use, and distribute the data as it determined in its discretion. So this is a very interesting decision. If anyone has time to read 100 pages of arbitral jurisprudence, this is how you should invest the time, because they went through the metadata and the deep analysis of what the app stores and what happens to the information. For instance, the employer said photos would be stored for 6 months, but they were actually stored indefinitely, thousands and thousands of photos every time someone had clocked in and clocked out, including for break times. That shifted during the course of the arbitration to actually just be the initial clock in and clock out. But every time someone was going on break, they'd sent a selfie and it had been uploaded. What's obvious to the employers who are reading these decisions, the employer wasn't only trying to overcome inefficiency of time tracking. They said they spent about 15 hours a week trying to track down papers and correct mistakes, but they were also trying to control for time theft. Because that's the flip side of the productivity coin, time theft. We know that electronic monitoring tools provide valuable data for monitoring productivity, but it also assists in addressing time theft and misconduct. And there's sometimes a fine line between someone who's being inefficient or distracted during work hours and someone who's simply being paid for work they're not performing. Sometimes, however, the line is not very fine at all. And recent cases provide employers with some assurance that time theft may still constitute just cause for termination of employment. The case of Bessie versus Reach CPA Inc. in BC is a really good case that helps us see where those guideposts are. The employer installed time track software on remote employee's computer in response to some concerns they had with her productivity. They had also scheduled weekly meetings with her to assess what work was being completed. The information collected demonstrated a 50-hour discrepancy on timesheets between work produced and work reported. The employee admitted she'd claimed some time on files not worked, but didn't provide a forthcoming or accurate explanation of that discrepancy. She was terminated for just cause, and she sued for wrongful dismissal. The adjudicator found cause to terminate, and they found, and the excerpt is really helpful, I think that we'll be using it again and again, given that trust and honesty are essential to an employment relationship, particularly in a remote work environment where direct supervision is absent, I find Miss Bessie's misconduct led to an irreparable breakdown in her employment relationship. A really useful highlight for employers on the additional element that the remote work and the inherent trust that's required in that scenario brings to things like integrity and honesty and accurate recording of work. And in the unionized, meanwhile, back in the unionized world, we have the case of Enbridge Gas versus Unifor. The griever worked on his own at work sites with minimal supervision. It used to be that there were two guys in a truck, and then with COVID restrictions, it became one. And the employer used GPS and computer tracking software to monitor the activities. The griever's employment was terminated for time theft, and the union grieved. The union submitted that the griever had previously worked with partners and there had been no consequences for sitting in the truck and not doing work. That was one of their the arguments they raised. But that as part of when he was in that, sometimes that one person wouldn't be doing work and they would be providing support to the second employer or employee. The company used GPS and computer tracking software, but the employer said, no, these were serious offenses. It's offense of time theft, dishonesty, and breach of trust. And given the new independent nature of the griever's work, it was even more important that the company protect itself against the vulnerability of misconduct. They also argued that the lack of remorse influenced the decision to deny any statutory entitlements to notice or severance pay. The union argued that the griever didn't intend to defraud or act dishonestly when claiming payment for the waiting time, and also noted that he had an accommodation need to run home and use the bathroom frequently, and that accounted for some of the time he wasn't there. The arbitrator wasn't buying it. The griever had repeatedly failed to go to work sites and had claimed payment for unattended time. They found that the pattern was a deliberate pattern of time theft constituting serious misconduct instead of a one-time mistake. And the OLRB wasn't having any of the complaint or the argument around health issues, finding that the griever had failed to notify his supervisor or requested accommodation. The board stressed the importance of honesty, integrity, and trust in the employment relationship and found ultimately that the discharge was a reasonable sanction for such serious workplace offenses. When we're talking about electronically, just as we round this section out, if it's before implementing electronic monitoring, we encourage you to discuss risks and best practices with legal counsel. If electronic misconduct such as time theft is suspected, ensure you have the necessary electronic evidence to support your suspicion, that it's preserved, that the integrity of the metadata is preserved, that you've met with the employee to provide them an opportunity to respond or explain, and that the discipline is proportionate to the misconduct and consistently applied within the workplace. We know that time tracking software is a valuable tool for monitoring productivity and addressing time theft, particularly in a remote work scenario, but employers do need to be mindful of those legal considerations. The recent decisions highlight the significance of trust, honesty, and maintaining a strong employment relationships in remote settings. And having that language baked into your policies is a great start. Moving to health and safety. Who thought that keeping a clean house might be a health and safety issue for the workplace? I certainly didn't. But we're seeing that in a number of jurisdictions, employees are claiming injuries that relate to the health and safety and physical environment of their remote workplace. In Ontario, occupational health and safety, the Occupational Health and Safety Act doesn't apply to work performed in a private residence. So it exempts most remote work arrangements from the OHSA application. But what's important about that is it doesn't exempt the application of some of the elements of the OHSA. So things like workplace harassment and violence will still be captured by the OHSA. It's just not, lighting and how deep your steps have to be and all of the physical environment issues that we often see as regulatory provisions under the OHSA. Those pieces don't apply. But an employer would be mistaken to assume that it's not something they have to be mindful of at all, because there are still pieces that will be woven into the employment relationship. But that exemption doesn't apply in any other Canadian jurisdiction. For instance, British Columbia and New Brunswick have obligations that relate to protecting health and safety of workers who work alone, and those apply to a work from home employee as well. And they're designed to address specific risks arising from work and isolation. I think that that's something that we're going to see soon enough. We've been chatting about that in our office about whether we're going to start seeing some changes to an employer's obligations to account for that isolated and remote work scenario, including mental health issues, I think would be the next logical step for some of the legislative intervention. In Ontario, the WSIA applies to a workplace injury sustained at home. So claims are adjudicated in the same manner that they're adjudicated anywhere else. The central question is whether the injury arose in the course of employment. So when did the injury occur? Where did the injury occur? Was the usual place of work or somewhere else? The backyard? That's a little bit of a preview to a case I'm about to discuss. And what was going on? What happened? Was the activity reasonably incidental to employment? The case of Air Canada and Gentile Paty in 2021, an employee was injured when she fell downstairs on a lunch break while working at home. She filed a claim with Quebec's Workers' Safety Board, and the tribunal upheld it. The claim was successful and the employer appealed. The ALT held that the injury met the definition of work accident. They found it to be a unforeseen and sudden event. It occurred in the course of work. They found that those who work at home are entitled to the same protection as those at the employer's premises. And while the employee fell on break, she was required to follow a very precise schedule that allowed a break at the time she fell. The concept of a break wouldn't make sense if the period was not connected to the employee's work. They also noted that the fall had occurred just after the employee had disconnected from work and while she was on her way to have lunch. ALT found that that employee was, as I said, entitled to the protections and seemed to set the precedent for the employee working at home. But in a plot twist, another case comes up. Allard and Promutuel Horizon West. And the employee was, in this case, it's the same adjudicator or the same body. The employee was on break and fell. She had, he'd been working in the basement, logged off and went to have lunch. After lunch was done, they dropped their personal cell phone and were injured picking it up. Here's your plot twist. That the ALT found that the injury did not meet the definition of work accident. They looked again at the location and the timing of the incident and found it did not occur in the course of work. It was outside the residence in the worker's yard. It was in the middle of the meal period after the worker had finished eating. And other considerations that they highlighted was that the meal break was not remunerated, the worker was not required to remain available during the break, and they were disconnected from the employer's network during the break. The cell phone the worker was also trying to pick up when it fell was their personal device and not used in their professional duties. So if that sounds like hair splitting to you, it probably is, which is a shock, I know, because usually employment law is so consistent. Not at all, I know. So what the ALT actually distinguished their Air Canada decision and found on the basis that the incident happened right after the worker had logged off and was on the way to lunch in Air Canada versus this case when they were in the middle of their break and in their backyard. So bottom line, whether an injury is in the course of work will absolutely depend on the circumstances. Practically, if a worker, how do we reduce risk? Have clear written policies and protocols regarding remote work, sort of general policies as to the workplace and setup and accident reporting protocols, including training, and then specific to that employee, such as duties while at home, hours of work, break times, productivity as applicable. That can often be handled in a job description or in an offer of employment. If a worker is injured at home, we still have an obligation to consider modified duties. You can look at alternative duties at the physical work site if compatible with restrictions. We anticipate most WSIB related claims will be related to ergonomics of work from home arrangements when it comes to the remote worker. So we encourage employers to consider proactive measures to reduce the risk. It's probably, when you think of the trajectory of some of these injuries and the development of injuries, I think we're getting very much into a ripening zone for when some of these complaints are going to be made and going to be litigated. What else are we looking at from a health and safety? As I said, we're going to focus in on some of the online harassment and bullying. According to a 2022 study, 38% of employees experience harassment in remote work, and 24% believe harassment abuse is worse in the remote work model. Email communication and digital meetings are often to blame, and that makes policies incorporate, or that makes it important that policies incorporate or reflect virtual work. Reminder, harassment policies will generally apply broadly to the workplace, which will include that digital workplace. So there's still that duty to investigate if there's a complaint of workplace harassment. The difficulty can sometimes be discerning between harassment and the reasonable exercise of a manager's duty, which is not harassment. And it's hard sometimes to pull the tone, particularly from email or chat correspondence. So when we're encouraging employers to be proactive about reducing the potential for harassment and complaints related to online conduct, we say amend the policy to expressly address online harassment, what it looks like, and that it falls within the policy. And then provide employee education on the distinction between harassment and management of a worker, but also provide them with clear instruction on professional communication and maintaining the standards of professional communication. What is and is not acceptable email and digital meeting etiquette. Evaluate if digital communication is stored for access in the event of an investigation. So even if the conduct isn't harassment, it might not be acceptable in the workplace, and consider whether we want to set out those parameters. It's not just what we say to people. Sometimes it's what happens on camera with facial expressions, gestures, or deliberate conduct. Studies suggest even rude emails can increase an employee's stress and detachment for work. And I just want to remind everybody that in Ontario, chronic mental stress is a workplace injury that's covered by the WSIB if the employee makes out their claim. So be mindful of that as well in terms of what we may see down the road. Consider when you're drafting the policy, which jurisdiction or policy will apply to Arash's earlier comments. If an employee in Ontario is corresponding with an employee in Nebraska, while there may not be, and I don't know if there is, legislation in Nebraska that deals with the workplace harassment from an occupational health and safety perspective, certainly the employee in Ontario will have the protections that are afforded to them as another worker in Ontario. So, Arash, I think it's your turn.
Thank you very much, Shana. So in this part of today's webinar, we'll focus on two questions. First question is, what are some of the employment standards that apply to a remote worker? And then we'll look at some of the considerations that govern the decision whether to permit an employee to work remotely. As we mentioned earlier, employment standards legislation in each province governs minimum employment standards for individuals working in that province. These include issues such as maximum hours of work, time off between shifts, and overtime thresholds. The ESA, for example, Ontario's ESA, governs both hours of work and record-keeping requirements. Proper record-keeping is essential part of an employee, is an essential part of managing an employee. In the case of a remote worker, it is even more critical because of the flexibility inherent in a remote work arrangement. Without a proper and consistent method of recording relevant facts about remote workers, a number of risks can arise. Beyond the failure to comply with the requirements, employers without records are often vulnerable to claims of unpaid overtime and unpaid vacation pay. Under Part 6 of the ESA, an employer must record dates and times an employee works, number of hours worked each day and week, and if the employee has 2 or more rates of pay, dates and times worked beyond overtime threshold at each rate of pay. There are also retention requirements. This information must be retained for 3 years after the day or week to which the information relates. The Act exempts certain class of employees from the record-keeping requirements. An employer does not have to maintain records of dates and times or number of hours worked each day and week for a salaried employee if the employee is exempt from hours of work and overtime provisions of the ESA, or the employer maintains records of hours worked in excess of the employee's regular work week and 8 hours a day, or if the employee has a different regular day of work, whatever those hours are. For example, under Ontario Regulation 285/01, a person whose work is supervisory or managerial in character is exempted from hours of work and overtime requirements of the ESA. In that case, the record-keeping obligations of the ESA with respect to hours of work do not apply. But if the employee is not one of those exceptions, an employer has to keep the records, even if they're salaried employees. Another issue addressed by the ESA is hours of work. ESA entitles an employee to at least 30 minutes of unpaid eating period, such that the employee does not work more than 5 consecutive hours without one. Practically, this means that in any shift longer than 5 hours, the employee is entitled to a 30-minute unpaid eating period. However, the ESA also permits the parties to agree that instead of the employee getting one 30-minute eating period, they get 2 15-minute ones. It is important to note that the ESA does not entitle an employee to a paid break. Some employers do provide employees with paid breaks, either as part of their policy or in accordance with a collective agreement. But the paid break is not something that's required by the ESA. It is one of those greater rights or benefits the parties can negotiate. As mentioned earlier, remote employees pose a challenge with respect to hours of work because it is more difficult to directly supervise them. From a practical perspective, it is important to have a clear and enforced policy for recording hours of work for remote employees. This could take many shapes. For example, you could require each employee to send in their hours of work on a daily or weekly basis. Given the flexibility inherent in a remote work arrangement, it is also important to determine how your recording system will capture flex hours. So for example, if an in-person employee steps out for half an hour to run a personal errand, it is easier to identify this fact and arrange for flex time. With respect to a remote employee, this might be a bit more difficult. Your recording system and policy should capture this. Another practical suggestion is to ask employees to fill out forms periodically, confirming that they have not worked any excess hours. While having such policies and procedures in place does not guarantee that we will prevail if an employee makes a claim for overtime, it will certainly assist us in doing so. One really important point to keep in mind is that just because an employer does not explicitly authorize an employee to work overtime does not mean that if that employee makes a claim for overtime, they would not succeed. The regulations and the jurisprudence are clear that an employer not knowing an employee is working overtime is no defense to a claim by that employee that they're entitled to overtime pay because they in fact worked in excess of their normal working hours. The ESA also contains provisions regarding home workers. A home worker is defined as an employee who does paid work out of their own home for an employer. These are not new provisions to the ESA. They predate the recent trend towards working from home. Historically, the provision was meant to address individuals who worked out of their own private residence, making products for their employer. The legislation intended to ensure that these vulnerable workers not only enjoyed the minimum protections other workers did, but were also fairly compensated for the use of their own private premises and resources to the benefit of the employer. Because of this historical background, a home worker is entitled to a higher minimum wage than other workers. However, the definition of a home worker in the ESA is broad enough to capture a modern-day remote worker. A fairly obscure and specific legislation has become relevant again. So as of October of 2022, the minimum wage for a home worker was $17.05 per hour, which is $1.55 more than the general minimum wage. As of October of 2023, the minimum wage rate for a home worker is $18.20. The ESA also has a number of provisions regarding notice requirements to a home worker. An employer is required to notify a home worker in writing of the type of work that they're employed to perform and the amount per hour that they will be paid. These requirements are typically met by a written employment agreement. Most employers do enter into written employment agreements, and we highly encourage that practice as a strong risk mitigation tool. A provision that's a bit less usual is the requirement under the ESA that the home worker be notified of production targets and the amounts the employee will be paid for producing that. So for example, if you hire a home worker to manufacture jewelry and intend to pay the employee per unit produced, then you need to notify the employee of the number of items you expect the employee to produce and how much you will pay the employee per unit. A few practical tips. Given the higher minimum wage for an employee who's a home worker, you should ensure that you pay a remote worker at least the minimum wage, which is $33,247.50 and increasing in October to $35,490. You should also ensure that the necessary information is provided to the employee. As mentioned earlier, most of this information is typically contained in a written employment agreement, but if it's not, you should make a point of including it. Last but not least, remote work can also give rise to accommodation issues. Under human rights legislation, an employer is prohibited from discriminating against an employee based on a number of enumerated grounds. Courts and adjudicators have held that discrimination has to do with the impact of the employer's actions on an employee and not on the employer's intent. So if an employee has a protected characteristic and received adverse treatment from the employer, and the employee's protected characteristic was a factor in that adverse treatment, that is likely to be held to be prima facie discrimination. Two of the grounds that employers most often deal with are disability and family status. So sometimes what happens is that when an employee who has been granted permission to work from home is required to come back to work in person, either fully or on a hybrid basis, they claim they cannot do so because of these protected grounds and ask for an accommodation. It is also possible that an employee may approach the employer and request a remote work arrangement as an accommodation without already having been working remotely. If this happens, the usual accommodation framework will apply, and we'll talk a bit about what that framework is. The first thing to bear in mind is that an employee who requests an accommodation must prove that they're entitled to an accommodation. They must provide the relevant details and documents to show that they have a characteristic that's protected by human rights legislation and explain what accommodation they're seeking. Sometimes this is easier to do than others. So for example, if an employee has a bad back and requires a specific type of chair or desk, they will need to provide medical documents of the nature of their disability, what limitations that disability imposes, what they can or cannot do, and what type of accommodation they would need. So in determining whether an employee is entitled to an accommodation on account of disability, we would typically focus on whether there is evidence the employee suffers from a disability, and if so, what restrictions arise from that disability. Family status can be a bit more tricky because the assessment can be a bit more subjective. In the case of family status, we consider whether the employee is in a parent-child relationship, whether the request for accommodation arises from a need as opposed to a want, and whether there are other supports available that might allow the employee to meet any childcare-related needs through other means. If an employee meets that threshold, that means they are prima facie entitled to an accommodation. But the case law is clear that an employee is entitled to a reasonable accommodation and not a perfect one. In other words, an employee is entitled to an accommodation that permits them to do their job with the necessary modifications, that they're not entitled to get exactly what they want. Some decisions describe accommodation as a two-way street. There's a give and take involved. An employer is expected to be flexible in modifying work arrangements and policies. And an employee is expected to cooperate in the process by being open and flexible. So even if the employee meets the threshold, they would not necessarily be entitled to a remote work arrangement. Rather, the question is, could the restrictions be accommodated with in-person work? Or another slightly different formulation is whether permitting the employee to work remotely would cause undue hardship on the employer. As a final point, you should not be afraid to ask questions or seek additional information. In fact, there is a procedural obligation on employers to ask relevant questions and consider all relevant documents. Sometimes what happens is that employees present incomplete or illegible documents in support of the request for medical accommodation. Generally speaking, if the information is incomplete, you will be well within your rights to ask for additional information. Sometimes employees present information from individuals who claim to be qualified practitioners, but who are not. If we have a reasonable basis for questioning somebody's medical expertise to provide medical information, we can do that as well. And probably the most important point is the need to be creative in this area. Courts and adjudicators have described human rights legislation as quasi-constitutional, which means obligations imposed by them are quite serious. As a result, adjudicators often say that the bar for declining an accommodation request is quite high, and employers must consider all reasonable ways of accommodating an employee. That's why, generally speaking, it's a good idea to consider all possible ways of meeting an employee's accommodation request before declining it. This brings us to the end of the presentation portion of today's webinar. We're now going to move into the question and answer portion of our discussion. So one of the questions that we have is, what if an employee relocates to a different jurisdiction for only a few weeks a year? In those cases, particularly if the relocation is within Canada, it is far more likely that the employee will be covered by the home jurisdiction. And there are two reasons for this. One is because of the temporary nature of the relocation, but it's also because the relocation is a continuation of the work that's done, because the work that's performed outside Ontario is a continuation of the work that's being performed in Ontario. But if the relocation is international, that changes things a bit, because you would want to make sure that there's nothing peculiar about the foreign jurisdiction's laws that will throw a wrench into that equation. The other question is, how do you define what's meant by permanent relocation? Is there a minimum amount of time? There's really no hard and fast rule about what is minimum. And this is an evolving area of law. We're concerned generally with where the employee is physically located, where they live and where they work, in terms of like the permanency of their situation, where they are predominantly located. But again, this is a really case-by-case analysis, and the decision of the board in IBM Canada that we discussed kind of illustrates that point. Shayna, over to you for any questions that you might have.
I have a number of questions here, and I have to say, Arash, when you're talking about these issues with relocating to another jurisdiction, I've never been more grateful that my law school made us take this like mandatory, talk about obscure conflicts of laws in international. I was like, what is this? Now it's actually finally, after all these years, very relevant. I wanted to remind everyone, just as we're coming through, that if you have questions, pop them in the Q&A, not in the chat. Chat's disabled, and we'll get to them if we can. And if we can't get to them, then reach out to us after. So my first question is regarding the Ontario ESA and electronic monitoring. Does this only apply if the company has 25 or more people in Ontario, or as a company as a whole? So the examples given, 10 people in BC, 20 people in Alberta, 30 people in Ontario, or sorry, 30 with 5 people in Ontario. And it's just the threshold is for employees in Ontario. So if you have 25 employees in Ontario, then you have the requirement for the policy. The question follows then, are companies required to have a standalone electronic monitoring policy, or can it be captured within an existing relevant policy? We certainly have seen a lot of employers put it into their IT use or asset use policy. And it can absolutely be embedded in another policy, provided you meet all the requirements that are set out in the legislation, and it's redistributed as needed. So we can't just amend that policy and leave it sitting on a folder on the computer. We have to circulate it. Two more before I pass them back to Arash. Regarding tracking in hybrid work environments, where the employer decides to track only at-home days and not in office days, could that create a fairness issue? Maybe, but fairness isn't a grounds for litigating or filing a workplace complaint. When an employer looks at how they're monitoring or the reason that they're using that electronic tool for monitoring, I pull you back to some of those first principles on when we're using surveillance. So if you're in Ontario and you've disclosed it and you've been clear about the purpose for which you're gathering it and how you may use it, it's acceptable. If employees find that it's a bit unfair, that becomes more of a morale issue, and you'll have to balance the interests that way. And my last question before I pop it over to Arash, what about electronic monitoring of an employee who's moved out of Ontario? Well, here's hoping you did all the things that Arash talked about on managing the relocation so that it's clear that Ontario law doesn't apply. If the employee is in Ontario, the policy applies to them. If they're out of Ontario, the policy likely wouldn't apply unless somewhere in the contract or they've been provided with a policy that says it applies to them. So sometimes, again, when Arash was talking about the importance of making sure you know what policies apply and how and the scope of those policies, we've seen issues where an employee, and this is the IBM case that Arash was talking about, where an employee identifies a greater protection or a greater right or benefit under Ontario law. They grab an employment agreement or a policy that says that they have that protection. And then we as employers are trying to prove that it doesn't apply. So the legislation wouldn't automatically apply. It's if we've somehow created some greater right or benefit to the application of that policy out of jurisdiction. Arash, back to you.
Thank you so much. So the next question we have is the following. If the employment offer clearly states that Ontario law to apply in spite of a move, and they signed that offer, will that clause still stand? So while the choice of law clause may be a factor the court will consider, it will not necessarily be determinative. If the move is within Ontario, this may be a more justifiable clause if the employee moves to certain provinces, because our ESA is more generous than most other provinces. However, if it is international relocation, then it is much less clear whether that choice of law clause will still actually be enforceable. For this reason, we strongly recommend that clients reach out to us or their employment lawyers for guidance about the particular situation that they may be facing. Another question we have is about breaks. Can a 30-minute unpaid break be taken after five hours of work? For example, 5 hours. For example, at 5 hours mark, or does it need to be taken prior to 5 hours? So an eating period must occur within 5 hours, such that the employee does not work more than 5 hours without a break. It can fall after the employee has already worked the full 5 hours. Shayna?
Back to me. I have to say that I always find the Q&A portion to be the most interesting part of these programs, and certainly provide a series of really challenging questions and scenarios. So here's one. With one employer, the clock machine that hourly staff use to clock in and clock out captures their photos. And then the question is, do we need their consent? So as a starting point, I'll remind everyone of my comments that you have sort of a different standard if the workplace is unionized versus non-union. But in either case, when the picture is being taken, something's happening to that picture. It's being stored. It's not going into the ether. So if you're in Ontario, this would arguably count as a retention of employee personal information, which for the purposes of administering the employment relationship in a non-union workplace wouldn't be captured. If you were in a unionized workplace, I think you are in the realm where that privacy interest might be starting to be encroached. In either case, the use, it's easy to manage that, right? And we've had employers ask us those questions. What about where we have a third-party security company use cameras in our workplace? Be clear about the fact that this is happening, it's being stored, because it's being stored offsite. Unless it's you that's aggregating and storing the data, you can't make representations about what's happening to that data. So I think that some notice is appropriate, and it could just be right there on the timestamp, and then saying, if you have any questions, speak to X. So not express consent, but a way to make sure that you can say that the employee understood the purpose for which it was being collected. We're now using tracking software to see if an employee is working when they're at home, and IT started to put the software on the computers. We thought there was going to be a wide communication. Any comments on how to proceed? If you have fewer than 25 employees, we would still encourage you to provide some level of disclosure if the data is being collected and stored and accessible offsite. It also helps in the event that someone's being disciplined or performance managed to be clear that this isn't the first time that the employee becomes aware that the information is being accessed. It can be a real trust issue if an employee discovers that the employer has been using tracking software. So there's a trust issue, but then there's also the legal issue. And my concern is if you're over 25 or more employees, absolutely, you have to have that in your electronic monitoring policy. If you're under 25 employees in a non-union workplace, there are still general principles of privacy that you need to understand what the actual functions and what information you're gathering to make sure that it's staying within the corners of what's acceptable surveillance in that non-union context. Arash, do you have a couple of questions you want to get through?
I do. Question is, if someone changes to work from home, does a new employment agreement need to be signed or drafted, or will the old one suffice? So if it is within the same jurisdiction, we would not typically need a new employment agreement, although we would recommend having a remote work agreement that would specify the terms and conditions of that remote work, and also policies kind of to go along with that, about exactly how remote work issues will be dealt with. But if it's in a different province, that may be a different issue. The next question we have is if someone is requesting an accommodation to work from home due to childcare or inability to find childcare, is there a time frame of how long that issue should last? Work from home shouldn't be a substitute for taking care of children. So what's reasonable? That's a very good question. Length of time obviously depends on all of how long an accommodation is reasonable, depends on all the circumstances. So we can't really kind of give a quick answer to that. So the board the employer will have to make an assessment about what it knows about what the employee's needs are and what factors, what resources the employee may have that would be able to meet those needs. Finally, can we ask for medical to support the need for remote work? Yes, absolutely. An employee who asks for an accommodation has to provide documents and information necessary for the employer to make an assessment about that request. We cannot ask for a diagnosis, obviously, and that's a very touchy issue, but we can definitely ask for the nature of disability, which is a much more general information that wouldn't disclose the diagnosis. Shayna?
I know this is a controversial statement, but I'm not so afraid of the diagnosis depending on the circumstance. I think arbitrator Surdykowski wedged the door open. So I know I'm not in the majority when I say that, but if you have a situation, it depends always, as Arash says, always depends on the circumstances. All right. Does the WSIAT apply to work in private residences? I am going to lawyer this answer. 1, private residences in Ontario. 2, where the employer is otherwise captured by the WSIAT, or sorry, WSIA. And then but I think what's really being asked is if a worker is injured in a private residence at home, if the employer is otherwise covered by WSIB, then yes, that's when we go through the analysis of who, what, when, how. Was it really a workplace injury? And we start to unpack it. But that's presumptively, if that same employee was performing work at the office or on the work site and would have been covered by WSIB as a covered employee, and now they're working remotely and they have an injury, you should treat it just like any other circumstance. You may dispute that the nature of the injury is a compensable injury, but the protocol is all the same still. Related to that, it was mentioned by me that the OHSA does not presumptively apply to private residences. And then the question is, what if there's an injury? How does the OHSA apply in terms of conducting a workplace investigation or inquiry? I would encourage you to think about that from the perspective of the WSIB. If there is an injury and it's covered by WSIB, you'll want to be conducting an inquiry into what happened, and certainly to try and mitigate any future injuries. If the employer is not covered by the Workplace Safety and Insurance Act, and an employee has an injury at home, presumptively the law doesn't apply. So you wouldn't have to do the report and the investigation. But we're in a period of transition. And so this is one of those situations where I would say that depending on the nature of the injury, you should still consult local counsel to understand what your duties are under the OHSA. So it doesn't apply to the extent that, no one's coming in and measuring the rise of my stairs to make sure that, or the sound of how loud the noise is in my house and whether I'm sitting next to a really loud machine that I've chosen to put there. So the OHSA doesn't apply in that circumstance. But I think that we are going to see increasingly cases come up where we try and find those margins on when an employer who's put an employee in place to work at home is going to be responsible for taking measures to protect the safety of that workplace, including, as I said, occupational harassment or occupational health and safety provisions around harassment and violence. Arash, coming back to you.
Thank you. Next question is this: if you have 100% remote bookkeepers with reasonably flexible working hours, what are the employer's responsibility if somebody resigns, given as the rationale that their salary increases are not keeping up with their cost of caregiving for their disabled child, and then claims having worked excessive overtime? And that's a very difficult situation for most employers when they are hit with something like that out of nowhere. And that's exactly one of the reasons why we recommend to employers to have those policies and procedures in place for tracking hours of remote workers, even if that's not necessarily required by the ESA. Otherwise, it may be challenging, and it is challenging, to defend against such a claim many months after the fact, especially in the case of a remote worker. The next question is, any requirements for pet care work for work from home arrangement? For any requirements for pet care work from home accommodations? No, pets are not deemed to be family members under the human rights legislation. The family status applies only to parent-child relationship. So an employee would be entitled to an accommodation under that ground only if they're in a parent-child relationship. So could be a child, could be I guess a foster child, etc. Next question, just curious, why does a home worker receive a higher minimum wage than a worker who travels into the office? Wouldn't it be the other way around? They get the benefit of no commuting, not paying for gas, etc. And as we mentioned, there are historical reasons for why home workers have that additional benefit, because in the past, the reason the legislation was drafted in that way was to compensate low-wage female workers who were making products from their home for the employer. Certainly, it's questionable whether that still applies today in terms of the way that business has changed, but it just remained in the act for historical reasons.
And that's interesting, isn't it, Arash? Because you think of like, and the example you gave, a lot of that work used to be piecework, right? So someone would, like tailors and jewelry makers and what have you, would be producing by the piece and being compensated on piecework with a guaranteed minimum hourly rate. And it just, like you said, you called it obscure legislation. It really is one of those peculiarities where there was very, very little relevance to this for 25, 35 years.
Right.
And suddenly we all need to know about it. And I think what I find, one of the questions that I'm kind of jumping ahead is, we talk about, someone's asking, what are some trends we're seeing? And it is interesting because increasingly employers are starting to look at revised compensation models where they say, okay, remote workers will be paid a lesser rate than in-person workers to account for the cost of commuting and buying your lunch and and the fact that remote workers, I've even seen some employers use geographic references for the market to be competitive to the market. So if you move to rural Ontario, your cost of living is less and you're no longer on the Toronto market. So all of that is shifting and changing. And yet we have this piece of legislation that suggests that somehow it's more expensive to work remotely. So I think that we are going to see some trends around compensation, around pay equity issues with people who are in those remote work or hybrid arrangements, if an employer starts to apply two standards. And one of our attendees mentioned that when they said, is this a fairness issue? When it starts to go into things like compensation and work opportunity, fairness might shift into a potential human rights issue or a pay equity issue. Sorry, I hijacked your question.
I was going to go to you, so.
Oh, fair enough. Okay, so one employer has required employees to conduct home inspections for safety as they operate on a hybrid mode. And if the employee signs off on that monthly basis, can the employer still be liable for it? Again, it's a workplace, just like here we have at our office, we are compliant with health and safety legislation, but if an accident happens, it's still very much going to be fact dependent on the circumstances of the injury, what happened, what any pre-existing conditions were, that sort of thing. So I think it's a really worthwhile thing to be mindful and to be doing check-ins. There are a lot of ways too that employers, particularly during the pandemic, started to turn their minds to the ergonomics of remote work, of standing desks or standing arrangements, multiple monitors, mandatory breaks, all of those things that are meant to mitigate some of that issue that you get when someone is parked with, seat in chair for extended periods of time. So anything that an employer is doing to be mindful of some of those situations is a good strategy. Our team is fully remote, and we also use flexible schedules so people don't have set break times, etc. Some start earlier, some start later, work earlier and later, depending on the day they have, their family obligations, their obligations. And the question is, how would this impact creating a policy around the breaks that's HS health and safety supportive, but still consistent with the culture we've built? I think that, again, building into the policy, the concept of some individual autonomy and direction, but you still need to be taking this time, which is a segue nicely into what Arash was talking about earlier with respect to the hours of work and the breaks, that we need to be able to prove, probably when it only ever comes out if it's in litigation, and we're usually on the defensive measure in that case, that the employee was taking breaks, that we've encouraged this flexible culture, but we've also created a sense of accountability to show how important it is that people are taking the breaks and maintaining those a little bit of that structure. it also segues nicely into when the right to disconnect was being talked about as a 9 to 5 kind of core concept. And we didn't know what the right to disconnect was going to look like until the policy came out and said, you just have to have a policy. You don't necessarily have to give them the right to disconnect. And I think that when we're trying to balance that cultural value of flexibility and productivity, that having a policy that really even captures that spirit, but reminds people that there's still things we need to do. There's still I's to dot and T's to cross. And of course, a lot of employers who have an American influence are moving to paid time off, PTO policies, or unlimited PTO policies. So even with that greater right or benefit, notionally, we still have to be able to track it to prove it's being done. Arash?
Thank you. Next question is, are there some relevant cases on family-based accommodation for remote work and how these requests have been adjudicated for help on guardrails on this topic? So to this point, we have not really seen much case law on family accommodation as a result of the pandemic. We expect to be able to see more of that in the coming years as the cases make their way through. Until that time, we'll treat family accommodation in the case of pandemic work from home the same way as any other request for accommodation on the basis of family status. And that's to ensure that the request is based on the need versus a want, and also ensuring that it is clear that when an employee requests for an accommodation, they don't necessarily get exactly what they want. It's always subject to the requirement of reasonableness on both sides. And obviously the requirement that the request ought not impose an undue hardship on the employer. And those are technical terms, legal terms, which I know most of you have heard, and we can talk more about that if necessary.
Wouldn't it be amazing if we could provide that flow chart of like if we hit this many hours or this many days, and we look at those Quebec decisions like bing bang, right after the other, where they take totally different hair splitting approaches. And I know that can be frustrating for employers, but what we remember, like Arash says, is be creative, ask the questions, get the information so that you're not in the passenger seat on these issues. Like don't give up hope. We can figure it out.
And don't want to be taken by surprise either, right? You don't want to hear, if you had asked that question, I would have told you that, right? So yeah. It's often the more the merrier in terms of information.
Yeah.
Next question. If employees would like to request to work abroad in another country, are employers' HR able to ask the type of legal rights they have to work from another country, i.e. work permit, citizenship, etc.? Certainly, if an employee requests to work abroad, it is prudent to ensure that the employee is legally permitted to work abroad. Should also, as mentioned earlier, we should also ensure that we engage local counsel to ensure that whatever we do is consistent with local laws, because local laws can be very different from what we experience. And when you talk to counsel in a different, in the far part of the world, you realize how different their legal system is. And I've been surprised myself when I talk to somebody, to legal counsel in, for example, Pakistan or somewhere like that.
Even Florida. Like I was really surprised when I talked to counsel in California, and I think you and I were working on this together, Rash, where an employee was looking to relocate for a month and, just did a check-in. This is early pandemic days with California Council. And they're like, yeah, if the employee is doing work for you while they're down here, they are working here. They are performing work that, in my view, is an immigration question. It's almost one of those things where I'm glad we knew. And the employer didn't want to get tangled up in any suggestion of misrepresentation. If the employee said, well, what if I just say I'm going down on vacation? That's never a good thing. The employer had to be mindful that they had a parent company in that jurisdiction that could also be impacted by the fact that there was a worker there. So there's a whole web of things to look at that make a one-off decision a little bit more challenging. You want to make sure that you're walking through all of the issues.
I think over to you, Shane.
After, okay, fine. So I'm going to take what I think is a more straightforward answer before I get to my next tricky one, is if you're a federally legislated company, does the electronic monitoring policy requirements still apply, or is it only in Ontario? And I'm so glad I can finally provide an answer that has a clear response. If you're a federally regulated employer, the requirement to have that electronic monitoring policy under Ontario law does not apply. PETA still does, and you have to be compliant with that, but you're off the hook in terms of the specific requirements of the Ontario legislation. Another question, are you finding a lot of cases around employees getting injured from home? And we have a work from home model, 3 days in the office, 2 days from home. Is incorporating a line in the employee handbook that employees are responsible for their own health and safety when we're working remotely suffice? And what are you finding employers are doing as best practices? So we're hearing from the Workers' Bar that there have been a significant increase in ergonomic claims related to work from home. And again, going back to casting my mind back to the early days of the pandemic when employees were requesting, like large workplaces who had to go remotely. They were requesting monitors, they were requesting stand-up desks, they were requesting all manner of ergonomic accommodations, chairs from the office, that sort of thing. And at first, a lot of employers were pretty resistant to it. One, because of the scale, and two, because of the notion of providing furniture and assets off-site. Some employers said, okay, actually, I see that this could help me mitigate exposure down the road because I don't want to see the WSIB claims. I don't want to see the back injury claims. So what I'll do is provide an allowance. I'll do an ergonomic assessment. I'll do some of these things. So what you can, having it in your policy that they're responsible for it doesn't hurt, but it won't close the case against the question of whether we've provided them. Well, not we've provided them. If they have an injury, they have an injury. But how do you prevent re-injury or reduce the prospect of injury is really the issue, because it's not the health and safety issue so much, just to split those two concepts. It's more the workers' comp issue that we're trying to be mindful of. And then my next question before I come back to you, Rash, is what are concerns that you think could or will be an issue in the future as remote work continues, trends that are popping up that are not case law yet? I really think that we're going to see some push on the expansion of protected grounds under the human rights legislation in terms of what constitutes family status. I think we're going to see mental health issues coming to the forefront from a litigation perspective. I think we're going to see an increased, whether it's cultural or generational, I think we're going to see more workplace harassment mindfulness of online conduct and social media uses and sort of integrating that off-duty conduct beyond what I said before too, which I think will be some pay equity and fairness issues with how people are being compensated, work opportunities for promotion. I think that we're going to start to see perhaps maybe a bit of a gender issue or a family status issue that weaves in with the people who decide to work remotely, and the people who decide to work in office. I think we're going to see some cases coming out of that. Arash, do you have any thoughts on what you might see down the road that I haven't already covered?
Well, I think the issues of human rights will continue to dog us, I guess, into the future, because it's a I don't want to say easy, but it's an interesting strategy for employees to adopt, and
yeah.
Employers will have to continue to be kind of mindful of the risks imposed by these difficult questions about especially family status, which was difficult in the past, right? But it's now even more difficult.
And I think hours of work and overtime, we're seeing those class action certifications for vacation pay and public holiday pay. And certainly, as you said, just because my policy may be that no one is allowed to work overtime unless authorized, that doesn't mean that that the employment standards doesn't still require that the overtime be paid. And if the employee presumptively, as you said, has the record, regardless of when it was created, not to be a cynic, but if they have the record that showed that they in fact worked 287 hours of overtime this year, then we're going to be on our back heels. So I think that we're going to continue to have some growing pains on finding that balance between flexible adult workplaces where we can trust our people and where we can reward their commitment with flexibility, and some bad apples who are maybe manipulating situations, and then some employers who just meant well but didn't understand what the requirements were, and perhaps went offside some of the legislation. So I think that some of those flexibility pieces will show up as pain points for employers. I have one more question. If an employer doesn't use electronic monitoring, do they have to have a policy for if they have more than 25 employees? Yes, but that policy may just be a simple confirmation that there is no electronic monitoring. So as you may recall at the outset, we talked about how there's the threshold question of, is there monitoring? So your policy may just be, no, there isn't. But again, you'll want to challenge yourself on what constitutes electronic monitoring. We've already heard some examples today that might cross that line in terms of we're not even realizing what the functionality of some of the apps that are being used could provide, including access to, like, if I'm swiping on my phone, creating data on when I access a building, right? Like my pass card is available on an app. What information is being tracked there? Is it identifiable to me? Those are questions that we'd want to be able to ask and answer. And we saw that in the earth boring case, that just saying that, you know, the third party told us probably won't be enough. Arash, do you have any other questions, or have we exhausted our audience?
I think that's it. Yeah, that's all the questions I have here. So
yeah, well, and that was I just want to say thank you very much to everyone for attending. Our next HR review is in September. We're taking the summer off, but we'll be back with an exciting topic to be determined. For those of you who do not yet receive our invitations, please join our mailing list, and on our website it's a little red button running the bottom end. Everywhere subscribed, you'll get our newsletters, our webinar invites. And for anyone who had questions today or afterward, you're thinking about something that we may have discussed, please feel free to reach out to us and we'd be happy to answer your questions. Again, the webinar will be posted online in a couple of days. And thank you all so much for joining us today. Thank you, Arash.
thank you, Shayna. Thanks, everyone.
Bye.